amazing. It's how that happens. And of course, you're so involved in the discussion, you don't even get to know, and 4.5 hours gone. So, Jonathan, thank you very much for being part of the symposium. Part 2 you're doing. Part 1, of course, 30 minutes actually is not enough, but I wanted a shorter session symposium because there is more coming up over in May, that World Mediators Conference, and also I said let's have a shorter sessions. Let's get as many people as we can. So that's I know your session was really short. 30 minutes not enough. So Jonathan, thank you very much. And of course, before a little bit about yourself again. You want to do that? What do you say?
Vikram, I'm very content that for anyone who's interested, you give a short summary. But if there are any specific points you want me to bring out, I will. You know me well enough to be able to summarize, but if you want me to answer any specific question, I'll be happy to.
I think what we're going to do is, let's just for a second, let me just put up what we're doing. I think that's also a little bit that we need to put out, that we're doing this symposium on mediation legislation, and of course all the questions that go with it. Of course, the how, what, when, where, which, who, why, and whatever can be answered, what can't be answered, we take it forward. The whole idea being, Jonathan, is that legislation is moving in different directions in different countries. And my issue, one issue is that I think the people who are drafting that legislation, do they even understand the process, or are they going with people who are generally legislating because they like to legislate? That whole colonial aspect, of course, that I had spoken about in that in the colonization decolonization symposium. So that it becomes an issue in terms of legislation. That's one thing, of course, you will discuss. And there are vested interests also who have an eye on mediation. So the training institutes, the institutions, they're trying to get in some way into the legislation. And if they can do that, imagine what it opens up for them. So considering all that, one, you'll give us a global perspective on how you see legislation, how you would want legislation to be. If you want to take up whatever's happening in UK, totally your wish. I mean, I'm sure that there is activity there, but nothing. I'm not saying that you have to. If you don't want to, then we don't want to get into that. But in general, legislation, a global perspective, and of course a domestic perspective. And for me, I felt both of them should maybe come in together. I mean, we've gone online, everything's happening online. Why should I not be able to get Jonathan in? Why should this restriction of what qualification, certification in my country, what is required? Luckily, we don't have that. I put out our law. Luckily, we don't have that. We can choose whoever we want. But in countries where they can't, if you can't get whom you trust, then you're going against the whole concept of the process. So those things, considering all those things, how do you look at legislation, and wherever else you want to take the discussion, your wish, please.
Vikram, thank you. If the question was simply what legislation is there in the UK, then the session could be very short, because I don't think there's any, I stand to be corrected, I don't think there's any specific mediation legislation in the UK. So it's all basically common law principles that the courts have, laid out over centuries, which of course apply, principles relating to how you make contracts and, how you terminate contracts and so on and so forth. Of course, there are court decisions on mediation, but there's no specific legislation I can think of, not on, for example, requirements to practice as mediator, duties of mediators, the mediation process, the practice procedure. No, it's basically in accordance with rules of different institutions that you may mediate under, or that you may set out, in my case, in my mediation agreement, rules that, let's say, a little code for the particular mediation that the parties sign up to when they appoint me as their mediator. We will shortly have some legislation because it's been announced just last month that the UK government is to sign the Singapore Mediation Convention. So yes, we will have legislation there, and that will be quite tricky because I don't know whether you want me to go into this aspect, but of course, most conventions deal to date, deal with the recognition and enforcement of either court judgments or awards. And those are formal documents which set out reasoning leading to a decision. And then perhaps an appellate court or the enforcing court will decide, do the reasons stand up? Is the decision correct or open to attack? Here, though, in the case of Singapore Convention, you're not starting with a reasoned, a set of reasons leading to a decision. You're starting with a settlement agreement. And that settlement agreement may be a lot more vague than a traditional arbitration award or court judgment would be. And so there are certainly challenges there, questions of interpretation, what was meant, what actually are the obligations being undertaken. So it'll be interesting, challenging to see the enabling legislation that's drawn up when, after the signature stage, we come to ratify the convention in the UK.
No, I think that is interesting what you're bringing out, because obviously when it comes down to the implementation, what kind of issues come up there, that only time will tell. But I'm just looking at it from in general. I mean, how would you want it structured, supposing the UK goes into drafting a domestic legislation? Because obviously Singapore Convention, there are certain things put out there, but domestic legislation is still open to you for, of course, in legislating for what's happening there. Well, what would you want that to look like?
The implementing legislation, well, look, it's I can identify some of the challenges. For example, obviously it's of big importance to the mediation process that it be confidential, because it's the fact of the confidentiality that the mediator can reassure the parties that when he's discussing with both of them or with each party separately, that there will be confidentiality that enables the parties to open up and disclose matters that would not be disclosed in a court or arbitration process. Now, when a court is asked to enforce a settlement agreement, which may be quite ambiguous, to what extent can it open that lid of confidentiality to inquire as to what actually went on in the mediation itself? That's a big question. It may aid interpretation, understanding of the settlement that was arrived at, if you can lift the lid on confidentiality. But what's that going to do to the sanctity of the, the all-important confidentiality in the mediation process? There are other issues, all sorts of other issues. For example, it's not, when does the mediation process terminate? Typically, you have preparations leading up to a mediation hearing. And that mediation hearing can, of course, be a physical hearing, or post-COVID, there's still a significant number of mediations conducted virtually using platforms such as Zoom or Teams, and that's probably here to stay. Now, is the mediation over at the end of that hearing, be it physical or virtual? Because it's not uncommon to find that actually discussions, not everything is concluded on the day of the mediation hearing. Discussions may then continue for a period of days or perhaps even weeks, hopefully not longer, before eventually a settlement is arrived at. Now, it could be a very big question, and it will be a very big question if you need enforcement under the convention. Was that settlement agreement drawn up as part of the mediation process, or had the mediation process in fact terminated sometime earlier? In which case, what you end up with, the settlement agreement you end up with, would not be enforceable under the convention, because it's a post-mediation settlement. So other issues. What about where there are, proceedings elsewhere concerning the settlement agreement that's been arrived at? What about the question, do you allow evidence? I mean, should evidence be taken from the mediator who both benefits from and is obligated to respect the confidentiality that is so integral to the mediation process? So there's a whole host. It's not a straightforward matter. At the superficial level, you've got an international mediation that's enforceable under the convention. Isn't that wonderful? But then when you start looking to where the complications can arise, I've just, I think, listed a few of those that could arise and will require very careful consideration.
And what about domestic legislation? I mean, what would you want?
Well,
if UK does decide that you would need a legislation for, of course, your domestic mediation, is there some structure that you would want for that? How would you want that to look?
Sorry, are we now departing from the question of enforcement and just legislation
in general, yeah,
to deal with mediation in general? Well, as usual, that the competing priorities, as I see it, are the less legislation, the better, because mediation is inherently and must be a flexible process. And the more legislation, the more lawyered the process will become. And that's to be avoided if possible. But then the competing consideration is that the public who will bring their disputes to mediation need a certain level of protection. And that raises questions like, at the moment, anyone, as far as I'm aware, can, without any particular qualification whatever, can put a nameplate over the door saying mediator and set up a mediation business providing mediation services. Does the public need protection so that you require certification as mediator? Does the public need financial protection so that you require mediators, you mandate that mediators have to ensure that there are certain standards, codes of, just as we have with, for example, the legal profession, code of ethics, how we're supposed to behave. So those are the competing priorities: protection of the public who come to mediation and certainly deserve protection in those key respects. On the other hand, the fact that over-regulating the process will end up killing it.
Because I think the certification part of it really has to be, I think, looked at quite carefully. I mean, I still feel that we need to look at it carefully, because on one end, I mean, of course, in terms of certified people in the UK, there's no dearth of. You have some, I think, 18,000 certified people, but mediations not really happening. So certification by itself, and even going and getting registered with the CMC and all that insurance and everything that is already in place, all that is in place. I mean, it's not something which is not in place, but ultimately not translating into mediations. So where is the issue there? Is it just legislation you're waiting for, or is there some fundamental issue in the certification process and all that? I mean, objective, I mean, Jonathan, anything. I mean, how do you look at it?
Well, the figures are not so bad. I mean, the best evidence we have in the UK on figures comes in the form of the CEDA biennial audit. We have a very recent one, and that in terms of figures, I think pre-COVID, they were reporting about, and this is civil and mediations. So there are, of course, family and other areas, community, not covered by the CEDA report. But I think the figures now are, well, pre-COVID were about 16,500 mediations. There was a drop, perhaps unsurprising, during the COVID period, although I have to say that I was pleasantly surprised to find how well you could run things virtually, how well it worked using platforms such as Zoom. But there was a drop in numbers. And now I think the latest report concludes that we're up to slightly higher than the pre-COVID level at 17,000. But then you compare that with the number of contested civil cases listed, for court action, and that's running at nearly 250,000 cases a year. So the cases being mediated are not thus far reaching even 10% of that level. But that said, there are other moves afoot which are bound to increase the number of mediations. There are steps towards making mediation mandatory at the moment for small claims under £10,000, I think. And then there's talk of widening that to cover all the civil and commercial claims within the jurisdiction of the county courts, which is a far higher level, and would account for the majority, I would guess, of that nearly 250,000 annual claims. So that's bound to make a significant impact, have a significant impact.
Well, I don't know, Jonathan, that part of it is also quite debatable, whether that mandatory mediation is good in the long run, because definitely countries have implemented that years back, and it hasn't really translated into work on the ground over time. So, I mean, is that a good long-term strategy? Because what is really happening in the court system is, because one, the mediators get almost close to nothing, very nominal amount, and then there is this whole pressure on the settlement part of it. So the process is conducted in a manner which maybe people don't go back happy with. They don't go back telling people, good stories about it, so the word of mouth doesn't develop. So in the long run, I mean, because finally you want work to develop on the ground on a long term basis. You can't always rely on people going to the court and being sent to mediation, which has been happening for years in places, but it hasn't been able to develop mediation outside the court system. And I mean, I am looking at it from developing from there, because that's a long term strategy for the country, because you can't keep funding people's disputes. You have court time taken up. You have using taxpayers money to fund it in some way. So that can't be the long term strategy. I mean, I feel that we need to relook this, because you're already starting that process of mandatory, and it's going, that aspect is also going into some absurd aspects in the UK itself, in terms of how judgments are coming out on the way, whether you did it in good faith or not, where you I mean, those kind of various kinds of things coming out from the court system. They might have their self-interest to push mediation, but is it really detrimental to the development of mediation? I mean, those also, Jonathan, you have to have that. Give us a broader picture on that.
There's no doubt that there are dangers if you open it up very wide, and if you have, I mean, at the moment, my impression that most of those 17,000 mediations are conducted by a dedicated band of enthusiastic and competent mediators, giving mediation a good name. And there's the danger, if you open it up too wide, that you will have a wider band of mediators, not all of whom are as well qualified. And it's true that poses dangers, because in a different context, I heard years back as a lawyer, if you do a good job for a client, he will tell 10 of his friends what a wonderful lawyer you are. If you do a bad job for a client, he will tell 30 of his friends what an awful guy you are. So I guess you could extend that to the mediation context, and we have to guard this very jealously, that the reputation of mediation and of the mediators who are conducting these mediations is at the highest level, to ensure that the mediation process isn't sullied and given a bad name. Of course, that's a very important consideration.
Because Antonio, I have tried to dig deeper into the US experience, because a lot of people talk about the US experience in the court system. And I've spoken about it a number of times, I mean, lots of times, a little too much maybe. But the fact is that the whole mediation concept in the court system has ultimately got into the hands of the lawyers. So they control the entire process and everything. One aspect of it is, then again, for people, it is still, mediation is connected to the courts, and over these years is still connected to the courts. And outside the court system, it hasn't developed the way it should have over the last 50 years. That concept of word of mouth and telling even 10 people, if you tell 10 people, it should have multiplied into lots of, if you had so many users and they say lots of things going into mediation there, you would have had lots of mediators coming out and saying, okay, now let me look at private practice. But what is really coming out is that these people are used by the lawyers, the ones who give it kind of for free in the court system, thinking they'll be recognized by lawyers and get private work. They don't get private work. They get disillusioned, move out, because finally livelihood is also something that people have to obviously take care of. So it hasn't developed mediators to the way it should have. And that's not what we want. That's not good for mediation if you can't develop mediators. Yes, for lawyers, perfectly all right, which is already started. I mean, I look at things happening in India in the court system. I'm not part of it, but I do hear about how lawyers have, I mean, they're getting their fees, they're controlling the process also, and the mediator is getting almost nothing. So in that kind of a situation, is it really good for the development of mediation? I mean, really, that is the real question there, because we had one Ecuadorian example. There were Gabriela and Jimena from Ecuador. They're saying there is no mandatory mediation in Ecuador, and mediation is doing really well. I mean, in terms of the youth, her concept very nicely. She said, Jimena, that it's the experience. People are experiencing mediation and they want to do it, and it's developing in that sense. And I think that's the way even the courts, They should push it in that way that, yes, it's a good process. Please try it. We are here. I mean, we are here. You can always come to us. But why don't you try this and put it in that sense? Maybe. But if you say, no, now we are going to push you also, we are also going to look at costs if you don't go into it with good faith. There is a settlement proposal that came. It was a reasonable proposal. You should have taken it. Costs coming into it. They're interpreting it in that way, which is, I'm saying, not good for the way people are going to perceive mediation. I don't know what your thoughts on that are.
I think it's not a bad thing that I don't see the harm in looking at ADR in the context of, existing dispute resolution processes and having the courts and also arbitrators, even under a duty. I mean, some years back, I wrote an article suggesting that arbitrators, as well as judges in court, have a duty to stay arbitration proceedings if their view is that real savings can be achieved if the parties can engage in mediation, if they stay the process so that mediation, they can't compel it, but they have a discretion then to award costs against a party who seem to be blocking what they and the other party regard as a sensible idea to go off and mediate the issues. So I don't see that that's doing any harm. The fact is, and I tend to deal mostly with international commercial disputes, and those are endemic in the commercial world. And still, the knee-jerk reaction is, well, the contract says court or it says arbitration, let's do that. And if you can have judges who say, well, yes, but have a look at what mediation has to offer here. That's not a bad way to be spawning mediations. But I do see, I have to say, probably an increasing number of mediations where the parties have not yet started either court or arbitration, and they want to, before going to what the contract mandates, court or arbitration, they want to explore the possibility of mediation. So there's nothing to stop that, but it's very good, I think, that when you are at that final resort, that those with stewardship of those processes, the judges, the arbitrators, are aware of the benefits of mediation in terms of, reducing the incredibly high cost, blood pressure, financial, every sort of cost of fully contested court or arbitration proceedings.
Absolutely. No, one, of course, like you said, people are exploring the whole, going in for mediation before they even approach the courts and going into arbitration. I mean, that's the ideal situation. That's what we have to move towards. And that's why all this discussion as to how that can be developed. But that's one thing. On the other is the discussion on how the courts and their backlog, how can we handle that? So I think there are two different aspects of it. And if you, like I said, one is long term, one is short term. So is the short term going to affect the long term? And if countries have to look at that aspect also. But what is important, what you said about arbitrations, and in our law, this is 1996. Very nice. Let me read this out to you. It is not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement of the dispute, and with the agreement of the parties, the arbitral tribunal may use mediation, conciliation, other procedures at any time during the arbitral proceedings. So it has been put in the law itself that this is something that should be, is it the duty of the arbitrator, I would even look at it as a duty of the arbitrator. So it's all there. I mean, it's all there. Provisions are there. But finally, who are the ones who are controlling the process or comes up, and whether the lawyers approach this aspect of or it or not. But one thing we keep speaking about.
Well, Vikram, I'm not sure I'd like to have the arbitrators conducting
Yeah,
the
that is an
mediation
issue.
process,
That's an issue. That's an
which,
issue.
if I heard you correctly, was
It is an issue. Totally, it's an issue.
the wording of the English Arbitration Act is a little more general in that respect, and less. I can't remember it by heart, but it's along the lines that the arbitrators are under a duty to conduct the process in such a way as to avoid unnecessary expense or delay. And I argue that that means that the arbitrators are under a positive duty. If they think at a certain point, costs are racking up and the delays are incredible, each party is flooding the other with applications and documents and all sorts, to order a stay so that mediation can be attempted. Now, I see that as part of the arbitrator's duty to see that the matter proceed in such a way as to avoid unnecessary expense or delay. So that is there. And of course, the judges in England have for many years been upholding mediation provisions, and for years have been suggesting to ask the parties to advise whether they've considered mediation, and if they think it should be considered, then to order a stay of the court proceedings so that mediation can take place. There's a case reported on Lexology today on, was it a precondition, I think, to arbitration? I forget whether it was court or arbitration in the particular case, that mediation take place. I think it would have had, in the case reported today, there was a problem with a limitation period. So if the parties went off to mediation and didn't protect time, then there was a question of a time bar intervening. What powers did the court have? Could it order a stay of the court proceedings so that mediation happen, and so on? So, there are very regular cases in the courts over issues such as that. And we're seeing, I think, a more and more positive attitude on the part of the judges towards encouraging mediation. Now, I can't answer the question, what is the recipe to ensure an ever-escalating number, so up from the 17,000 and approaching towards the 250,000 that are destined for court. But we see that, I think, of parallels with, a new court is established. For example, one I was quite familiar with because I practiced for a while in Germany, the International Tribunal for the Law of the Sea, new tribunal set up in, it's basically a UN court dealing with maritime issues, illegal fishing and such like. And for years, nothing was happening. But then at a certain point, and you could ask the question, what exactly happened? Why at this point? Numbers start to explode. So are we on the cusp of it now in the UK? Is the 17,000 just this little lull before the explosion, and, within the next few years, we'll see it dramatically rise? I can't answer that question. And what is the recipe to make it rise? Can't answer that question. but I'm confident that it will rise. Will it be the slow, steady rise that we've had, till now? Although, it has to be said, 17,000 cases a year, it's not insignificant, but it's a small percentage of the total.
Yeah, but
So
also,
if we continue to conduct mediations well, so that those who've been through the process tell their colleagues and share with their circle, the success of the mediation they just experienced, that is bound to will that create the dynamic growth that we all as mediation enthusiasts hope for? I don't know.
No, because I tell you what also we have to look at is that, of course, 17,000 mediations, but who are the one who are doing it? One, is it now still connected to lawyers? Right? Lawyers have to do this, and that is the perception of people. Again, this is, I say colonial, you were the colonizer, but I say from a colonial concept that dispute resolution has to happen in courts and lawyers have to be part of it. So is that now getting into mediation without it going as a mandated thing already? And then when it becomes a mandated thing, that connection with courts and mediation also then becomes stronger. So then does it affect the development of mediation, which has to be much broader? Look, in terms of work, I mean, I'm sure lawyers have enough work in the courts, but if this also goes there, then the development of mediation with people who are non-lawyers, because that has to develop. Because you might say that 250, whatever, I mean, how many, we don't know exactly, I don't know exactly how many go into courts in general, all disputes, but many more are out there which need to be resolved at the earliest. So if there is lots that should happen for mediation, but once it gets connected to lawyers and courts, does that limit the scope of mediation for people or the perception of mediation?
I can't give you the percentages, but there are many very highly regarded non-lawyer mediators practicing, mediation on a full-time basis. I can't give you the percentage, whether it's 60-40, 60% lawyers, 40% non, 50. I don't think it's as high as 50% non-lawyers amongst those who would describe themselves as full-time mediators. But there is let's say, a significant number of non-lawyer mediators, and long may that last. I think it's good that should be the case. Vikram, I've just noticed the time that I've exceeded the 30 minutes you allowed me, coupled with the previous 30 minutes. I don't want to keep other
there is no one. This is
invite.
No, this is your session. There's no session after yours. So we have enough time. And of course, if you have something else to do, that's a different thing. But we need, look, your inputs are required. I'm going to another part of it. Of course, again, connected to certification on two aspects that I was discussing in the symposium. One, legislators themselves do not require any qualification certification in most countries. I can't say what the situation in UK is. You can tell us what the qualification certifications training for legislators is. The other thing is for arbitrary. Nothing. The point was that you should be able to elect whoever you trust. And I feel that's the same thing that should happen for mediation. That's one thing. Now for arbitrators, is there some certification, training, and some regulation for who can be an arbitrator? That's another thing. Most countries don't have that also. Why are we so focused on doing this for mediators? I want to understand this. There is like Turkey. Yesterday Ashan was there from Turkey. She says for mediators, they have to be lawyers, and then they have to give an exam to be mediators. There is no bar exam for lawyers. I mean, in general, there's no bar exam, But for mediators, there's an exam. What are we trying to put across? Is there some rocket science which needs some such specialization to a certain degree when this person is not even passing a decision? There's no decision this person is giving, assisting you. Why? What is this thing? Are there vested interests of training institutes which have got into it and are able to control this? Well, I find it absurd when they go into this direction. Arbitrators, no issue. Anyone can be an arbitrator. No problem at all. What are you doing? Only given an arbitral award which is binding on you. Mediator is assisting you. It's a you have to be very careful who's assisting you, because it's going to be your decision. That's very, very serious. Same thing with lawyers. I mean, imagine there's no bar exam there. You can go represent someone who's on the death penalty. That's okay. That's nothing. But mediator, and he's sitting with you, assisting you, very dangerous. You should not be able to do it. It's absurd, Jonathan. I think it's absurd.
Vikram, I'm not sure what jurisdictions you're talking about with no bar exams. Certainly in the UK, you cannot set up as a practicing lawyer without having the qualifications, the professional qualifications, and then there's the code of conduct, and there's mandatory insurance, and so on and so forth. So the legal profession is very fully regulated. Arbitration, no, I think it's right that in theory, anyone can set out, just as the case with mediator, you can, put that plate above the door, arbitrator. In practice, the arbitrators I know, they've grown out of, no, when I think about it, most of the arbitrations I do are London Maritime, LMAA, London Maritime Arbitration Association arbitrations. They do have that body, has a, let's say, certification process so that you only become a full member by demonstrating certain qualities that you're fit to practice as arbitrator, and certainly in that domain. Arbitrators have very, very next to no liability, just like judges. So perhaps insurance isn't quite the same importance as with mediators, where, you can see immediately, I guess the key candidate would be the confidentiality issue. If you coming to me as mediator disclose all sorts of things in confidence, and I then blow that confidence by revealing it to the other party, you may lose what could have been a very profitable deal with someone else or whatever. So, there can be big liability issues that could arise. So I'm not sure your specific question, whether you're suggesting it's a bad thing to be regulating mediators at all, then I wouldn't agree with that. I would agree that you need to be very cautious how you do it so that we're not over-regulating.
I think what I was trying to, I was trying to tell you about the comparison in the same jurisdiction. Turkey, only lawyers can be mediators, and they have to give an examination. Lawyers for the bar do not need to give an examination. So I'm comparing in the same jurisdiction how absurd things become. The other thing on the arbitrators part of it, if a certain institution wants to put through whatever they want to put through for arbitrators, that's a separate thing. That's the institution which can apply same thing for mediators. The point is that there is no certification required to be an arbitrator. You can be an arbitrator. Anyone can choose you as an arbitrator. It's up to them. It's not regulated in that sense. Bodies can do it. I mean, that's the way anything develops, any activity develops, that certain people want to go to certain people, and that's perfectly all right. That's choice. That's a choice. But when we start off with this whole concept No, we have to certify this person. First of all, on what basis do you certify? Do we even know so much about how mediation happens and how this individual is going to conduct some future mediation in some unique dispute with some unique people? Can't we just leave it to the trust of the people, their intelligence? They are going to trust whom they will trust, and they will disclose what after they trust, and that person is going to, that word of mouth aspect of it, is that does not have any role to play in the entire process. How does anything develop? I'm just saying, where does it start? Where does it go forward? Are we even in some way not letting it develop with all these ideas that we want to push in terms of the negative aspect of it, that this will happen to you, even if there is, supposing there's a breach of confidentiality for a moment. I'm not saying that's ever that it happens or if it's going to happen. Supposing it happens, how do you take that forward? Do you say this person breached the confidentiality? Whom do you bring in? Who's going to come and say, yes, this confidentiality was breached? Are you going to, I mean, how would you do that? What would really happen in that whole process? How do you look at that?
By the way, my short answer to your suggestion, leave it completely unregulated, would be no. That would be my short answer. Because there is, as I said before, and I don't want to repeat myself, protection of the public. And how you deal with breach of confidentiality is another matter. Coming back, though, to your suggestion that, isn't it crazy that anyone can set up as arbitrator and the arbitrator is making a decision and that's significant, whereas in mediation, it's the party's decision. So if anything, I think your suggestion was you should first, if you want to certify one of the two, it should be the arbitrator rather than the mediator. But another consideration might be that with an arbitrator, at least in the UK, where there are possible appeals from arbitrators' decisions, and there's a range of protections through the Arbitration Act. It used to be called misconduct. If the arbitrator has not followed the rules of due process and so on and so forth, then it will be controlled by the court. If the arbitrator has come to a crazy decision, the court may be able to deal with that. So you don't have those protections where it's a mediation. What if you have an unscrupulous mediator who has an undisclosed conflict of interest and has encouraged one party to enter into a settlement which will hugely favor the other party with whom that mediator has that undisclosed connection? Those are really, really serious things. And so you have to be able to regulate to the extent, I think, to protect the public.
But I bring it down to, again, a colonial mindset that we know better than you. You are savages. You don't know whom you can trust. We will tell you whom you can trust. And it starts from there. That's why legislation, I'm telling you, the colonial concept of legislation, that is the issue with it. People should not be left to themselves. We have to interfere. We will tell them what is good for them. We know who's good for them. They should not trust anyone. We should be involved in it some way or the other. The point is, finally, who is signing that agreement? Someone, they have to themselves sign it. I mean, are you saying that someone is going to force them to sign it, and which is not something beneficial to them? Then I'm saying we're questioning their intelligence. And it goes back to the colonial sense. You are not intelligent. You are savages. You have to tell you whom you can trust to get into something which you agree on. No one is forcing you. You've agreed to something.
Vikram, if the UK Ministry of Justice is telling or even suggesting to the Indian legislature how they have to deal with the regulation of or certification of mediators, then I'm blissfully unaware of this.
No, I'm not aware
that. I'm not aware that the UK is telling
No, no, you're getting
anyone
it wrong. No, no,
tells
you're getting
what
it
to
wrong. No, no,
do
you're
in
getting it wrong.
this
You're
domain.
getting it wrong. You're getting it wrong. I'm saying that's a colonization mindset. You were a colonizer. I'm not saying that that mindset doesn't exist. I'm saying mindset for your own domestic legislation. It's not, there is colonization of mediation, yes, which I've discussed, that how certain parts of the world have carried their concept of mediation to other places, their certifications to other places, and tried to create, there is a certain, whatever I call it, a class distinction. Oh, you're certified by this person, so you're a mediator, but people trust you to be a mediator. No, that's not good enough. You are savages. You don't know whom you can trust as a mediator. That class distinction is another colonization of mediation.
Yeah,
But
but Vikram, let's get into the real world. Today, so much, you talk about trust. Trust generally, trust will come from knowledge and experience, from knowing the people. But we deal mostly these days, gone are the days when you would, go to your trusted trade person, whether it's to fix your fuses or to mend your roof or to service your car. Today, so much is done online with people you don't know. And where is this trust supposed to come from? And you're asking, perhaps, let's say in my case, where it could be a party from anywhere in the world who has a dispute with another party from somewhere else in the world, who will not know personally the band of mediators in the UK who may be competent to conduct that sort of mediation. So where is the trust supposed to come from? And you say, but you said just now, but it's the party who will sign the settlement agreement. So he'll know what he or she is comfortable with. But I just before gave you an example of how that party could be somewhat duped, because unbeknownst to him or her, there's a mediator who has an undisclosed conflict of interest and is therefore leaning, to put it, without overstating it, is leaning on the party to enter into a settlement agreement that is less than ideal from that party's point of view. That's not fanciful, and that's something that needs to be rigorously guarded against, and there need to be sanctions that can be applied to if that has actually taken place. So it's Vikram, I'm going to have to go very shortly, but I would just say I can't really improve on in this regard on what I said earlier, that there are these competing considerations, that you want minimum necessary legislation. Absolutely, I'd agree with you. Minimum, keep it to a minimum, because the more you have, the more likely the process is to become over-lawyered, over-bureaucratic, over-complicated. Certainly you want to avoid that. But corresponding, the countervailing consideration is you want sufficient protection for the users of mediation so that they are not going to be exposed to the sort of situation I just described.
So basically, putting in a legislation that you have to disclose the conflict of interest is easy to do. Ireland has done that. Ireland in the legislation have said that you have to disclose conflict of interest. That's okay. That's a simple thing to put in a legislation. That's not an issue. Those are simple things. But how I'm looking at it is you have to look, legislation is going to affect a large number of people, and in your case it'll be a smaller number of people. In a country like ours, a much larger number of people. But the thought behind the legislation starts with people who look at it, I feel, from a very narrow perspective. 1.4 billion people on the other side. Thought process might start from 60 million in a certain country, that okay, this is what legislation looks like in that country, let's put it. So why I'm trying to put it across to you, be it a smaller country or be it a larger country, I think that certain aspects of the way mediation should progress, and maybe it hasn't gone that way, but we have to take it there. And again, a long-term strategy. But trust exists. I mean, there is a trust factor. How it comes, it will, people are going to check on Jonathan. They'll ask people, have you worked with him? They'll ask, they will find out in various ways about you. They're not going to make you a mediator and disclose confidential information with you to you up till they haven't done all that. People don't watch movies up till they don't ask 10 people. They don't eat food at a restaurant, they get reviews from there. They're going to come and disclose all their confidential information without even checking on you. I don't see that happening, be it an online world, an offline world. People need that trust, and they will find it somewhere, and you will live up to that trust, because that trust comes from various factors, and lots of people are going to be asked. I think that aspect, I still believe that yes, people can be trusted. So we'll find those people, and people will find those people. So not an issue at all. But I'm just saying that sometimes what happens is that certain narrow concepts of, like someone had put a comment here about should be part of an organization, but and then it gives that some kind of respect to the profession and all. I'm saying an unethical person.
Yeah, Vikram, look, there was, to disclose in effect my age, when I started flying, you could arrive at the airport almost as short a time in advance of the flight as you would for a train. Then someone started bombing airports, hijacking planes, and we now live with the fact of extensive security in airports before you get onto your plane and so on. Would you say that, well, forget it, forget about it, it's such an inconvenience, forget about it, dismantle all that security apparatus? I'm suggesting that even if it's only a few horrible examples of mediators who misled parties into really bad settlements because, for example, of a conflict that was undisclosed, conflict of interest. I'm saying we have to have that in mind, and we have to deal intelligently with it so as to provide that sufficient level of protection, which, let there be the research to go to trusted mediators and, let the whole panoply of legislation be largely unnecessary, fine, but let there be that sufficient level of protection to ensure that the bad eggs, you're dealing with the possibility of really bad eggs. Vikram,
give me 2 minutes. 1 minute. I'll still have to take 1 minute of yours, because I'll have to answer this. Because we've seen more corrupt politicians than we've seen bombings, and still it is unregulated. Still, you can choose whom you want to elect to. There is no certification. There is no qualification. There is no training there.
I didn't say that. I didn't say there shouldn't be, and I do agree with you.
But let's hit the politicians first.
To think of
let's hit them first.
Honestly, to think of any decent leaders in the whole of that's limited at the moment to the Western world. Isn't that shocking? Yeah, but we'd have to convene a different session on the politicians and how we deal with them.
Jonathan is connected because these are the legislators. These are the people who are going to make the legislation on mediation. But
I'm not thinking of appointing Rishi Sunak as my mediator, so I'm not going to deal with his certification.
No, not that. You will. Someone has elected him. I'm talking about electing someone. You are allowed to do that. Anyone can stand for election. And,
I do understand your point.
I know. I have to push that point because I'm saying unethical
Vikram,
people.
A pleasure as always.
One point. Let me put it across to you. It's important. Unethical people going for training or certification doesn't make them ethical. If that could happen, we would have changed the world with those kind of things. Them being part of organizations will not make them ethical. Unethical people will stay unethical people. So to say that we'll suddenly, while going through some 40-hour training, we'll make this person an ethical person, living in some dream world. I think people are. They think they'll go to they should be spiritual gurus who do this 40-hour training. They will change the person's concept of life. But these are thoughts. Yeah. So
I
Jonathan,
must leave. I
yeah,
must leave the last word
you
to you,
must.
Vikram.
No, 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 no,
And
no,
thank you as always
no.
for an enjoyable discussion.
Enjoy your
And
holiday, enjoy your trip. Is it a business trip or is it a general?
as I strive for these days at this stage of my life, it's a mixture of the two. It's a
Okay.
mixture of the two. Samarkand is a place definitely worth visiting for those of your audience who've not yet visited Uzbekistan.
Okay. Jonathan,
But I,
you should always take me along as a co-mediator. I will also see some. That's
be,
a good way
be,
of mixing
be,
it.
be delighted. I can certainly confirm I trust you without hesitation. So thanks. Thanks, Vikram.
All right. See you,
Good to
Jonathan.
speak.
Thank you. Thanks a lot. Thanks a lot. And if there's a
Bye.
workshop, you want to come in for that, your wish.